ownership and control is very significant. Ownership refers to the title or the vesting of the title. Control is much broader in its understanding because it's not confined to title. It is that, look, you could not have made that declaration because 39B cannot by any standard extend to private property. I think that's your...
No, my lord. With my lordship's kind permission, that's... My lords, before I attempt to interpret 39B, I would request your lordship to have a look at Article 39. The state shall in particular direct its policy. My lords, our case is that if it's a policy of the state, it can't be restricted to a few wards in a municipal corporation. That's our first case. Our first point is on the question of policy.
That way we have ground to challenge the act.
The act is under challenge, my lords.
That is before the bench which will hear the challenge to
So
the act.
I bow before your lordships, but when it comes to an interpretation, my lords, one point that your lordships have repeatedly been saying that if we feel that it's an academic question, we will not decide it. The point I'm trying to make here is twofold. One, before we go to question whether private properties would be material resources of the community or not, the question that we need to consider is what is material resources, one, and two, in respect of the matters before your lordship, is there a material resource? I fully bow to what my lord the Chief Justice said. We are not entitled to the property. We are on whether it's a resource of the community. My lords, again, the question here is not just resource of the community. Is it a material resource of the community? I'm emphasizing the words here, my lord. I'm on policy and I'm on material resource. Before I come to the question whether private can be included or not, this question might kindly be considered.
Must also bear in mind,
Please.
material resources of the community is in the context of distribution.
I bow before your lady. I bow before your ladyship's suggestions, my lady, because our case further, when we go through, I will take the liberty of taking your lordship through the act. Only that's chapter 8A, because that might clarify quite a few points. Is there a distribution of control? Is there a distribution of material resources? Now, material resources, once I can zero down and say that material resource should be that resource which produces goods or services for the community. If it does not produce goods or services, it would not fall within the category of material resources. That is my humble submission for your lordship's kind consideration. Here, my ladies, what is the situation? The situation is that a cess was levied on these landlords and tenants for carrying out structural repairs. The state says it is our duty to carry out structural repairs. When I say state, my lord, I refer to the board. If they don't carry out structural repairs, they don't give me the wherewithal to carry out repairs, my rent is frozen at 1940 levels, the cost of all building materials, construction materials are shorter, and I'm not put in a position to carry out repairs, would such buildings form a material resource, much less that of the community? This is a question which I would try to satisfy your lordships, that this is not a material resource, much less of the community. That's the first.
Clause B. Clause B has 4 aspects. The primary aspect is material resources of the community. What is it dealing with? It is dealing with the distribution of the material resources of the community. What facet of distribution is it dealing with? It is dealing with ownership
And control.
and control. Because are so distributed qualifies ownership and control.
Correct.
Ownership and control of what? Of the material resources.
And for
But
what purpose?
distribution of what? Distribution of the ownership and control of the material
Material resource. Now we are.
Now, what is the object? To subserve the common good. And the fact that the legislature, that the constitution uses the expression ownership and control is very significant. Ownership refers to the title or the vesting of the title. Control is much broader in its understanding because it's not confined to title.
Here, my lords, I'm raising two issues for your lordship's kind consideration. The first, as I already indicated, my lords, when the constitution says that the state policy of the directorate's policy, now, would it be only for the city of Bombay? Would it be only for the district of Nasik, or should it be that policy should be over the state? This is the primary question.
That wouldn't worry us because then the state can always make an under-inclusive classification.
Yes.
Then you say that, look, the condition of the buildings in Mumbai is so unique that you don't have to legislate, you don't have to regulate the entirety of the state. That the state can easily,
So,
that
here,
is not an issue at all.
my lords,
On
if
first
it were a regulation, my lords, I would have bowed to your lordship's suggestions immediately. But here it's not a regulation, my lords. Here it's not a regulation.
So, you know, we are not so much today interpreting the provisions of the statute as we are
No.
interpreting the expressions of clause B of Article 39.
I go to what my lord, the Chief Justice, has said, but I request my lord, the Chief Justice, to kindly consider whether we could interpret this, dehouse the facts before us. Because this question has come to your lordships on the basis of certain facts which were there.
But when we are interpreting Article 39B, we don't interpret it in the context of that statute today before the bench of 9 judges.
I would request your lordships to kindly consider
whether
it.
there is a dichotomy between privately held property and publicly. For instance, will 39B cover only those lands which are what you call in Maharashtra Gairan lands or the grazing lands? Or would it also cover in certain cases private
Only
property?
one interjection with so that your lordship's discussion can also be suitably. Resources, psychologically because of MHADA and Rent Act, we are considering land and building. The resources would mean several mines, minerals, airwaves, etc. Several things.
Natural resources as well as man-made resources.
Yes, exactly. No, not just land or buildings. That also may be one of the focus of examination.
My lord, I have no difficulty in the term resources. I have difficulty in submitting to your lordships that my building would be a material resource. Because your lordships have time and again held. Sorry.
What are these about?
Your so Devarajan is that, look, the MHADA Act contains a declaration that it is intended to give effect to the directive principle contained in 39B. Your contention, I mean, we are just trying to understand your argument. Your argument is that, look, you could not have made that declaration because 39B cannot by any standards extend to private property. I think that's your,
No, my lords, my submission is slightly wider than that. What your lordship says is one part of what I'm submitting. My second part of it is, before you could make such a declaration, because your lordships and Keshananda said this is justifiable.
Before you could make the declaration?
Before you make a declaration, you must come to the conclusion that it's a material resource.
Obviously.
I'm on that. I am trying to make a submission.
According to this can't be material resource.
According to me, it can't be a material resources. Old dilapidated buildings cannot be material resource of the community. This is my submission.
Questioning the declaration itself.
In a way, my lady, in a way, I'm trying to interpret 39B to say that before 39B can apply and the subsequent things can follow. Yes, when I interpret it, as my ladyship said, I need to go through the act to interpret the rest of 39B.
But why can't?
But I'm not going there.
Why can't it be interpreted like this, that any building, old, we are not dealing with a building. Buildings which are in the occupation, old dilapidated buildings in, say, like the island city, which are in the occupation of a large mass of occupiers and tenants, they constitute a part of the material resources of the community because ultimately it's a source of habitation and abode for such a large
No.
group of citizens.
My Lord the
And
Chief
residents.
Justice, I go to what your Lordship said, but my Lords have time and again said, made a distinction between a resource per se and material resources. This is where I would try to convince your Lordships that yes, this is a resource, but is it a material resource?
Just one,
Oh, I'm sorry.
add to what the Chief Justice has asked you. The material resources of the community, when you look at that expression, are we not also looking at the community of inhabitants in a dilapidated building?
Please, my Lord.
Because if you look at
Community may not
their
be
need,
India coming.
a building is crumbling down, a building is no more safe. So, community who are occupying that building, it is a material resource and a vital material resource for them.
Again, my Lord, I could not make my point clear.
No, no, I'm
That
sorry,
it is a
compare-
resource, that it is a resource the petitioners don't dispute. The question is it a material resource? Because your Lordships have said, for a resource to be a material resource, it should provide goods and services for the community. What is my building
Yes,
doing
sir.
so?
It provides a service. What is more fundamental than the right to housing?
No.
It provides a place of abode
No,
for such a large segment of the community. Take a building which has, say, 70 occupiers or 40 occupiers. It's a community, as Brother Hrishikesh Roy says, that it's a community of occupiers.
Why the community will have to fight for this community?
Absolutely.
Yeah, just continue.
Get to
Yeah,
it.
please, my Lords.